2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Clerk. And good afternoon to the participants, the lawyers today. I'm Judge John McClarty. I will be presiding over this session of the Court of Appeals. These proceedings will be conducted as if you were in court. I'm sure you have already been aware of your time limitations, and I'm sure you probably have already reserved your time for rebuttal at this point. Are there any preliminary matters that be presented to the court before we start?
No, Your Honor.
In that case, Mr. Clerk, would you call the first case?
Shelby County Board of Education et al. Versus Tennessee Secondary School Athletic Association.
And the lead counsel of that case who's going to be arguing will be who?
It's me, Your Honor, Rick Colbert.
Mr. Colbert, you may present your argument.
Thank you, Your Honor. I'm Rick Colbert, and with my partner, John Griffin, we represent the Tennessee Secondary School Athletic Association, and I've reserved 4 minutes for rebuttal.
Yes, sir.
Chronologically, Your Honor, this is the first of 4 cases that were filed in Shelby County Chancery in late 2017 and one in 2018, in which the Chancery Court there issued injunctions to prevent the enforcement of TSSAA eligibility decisions. The fourth one chronologically, but the first one to come to this court was the Robertson versus TSSAA case, which this court and 2 members of this panel of this court decided in 2019, I believe, and the court reversed the injunction that was granted in that case on the basis of the precedent in TSSAA versus Cox, that the courts are not to interfere in the internal affairs of a voluntary association. In this particular case that we're here on now, James Wiseman and Ryan Boyce, 2 high school basketball phenoms, transferred to East High School to play for another phenom in his own right, Penny Hardaway, who was the basketball coach at East High School. And they transferred after having played for Team Penny, which was Mr. Hardaway's elite independent team. Sometimes we refer to them as AAU teams. TSSAA determined that James Wiseman and Ryan Boyce were ineligible for a year under the transfer rule because there's a provision in that rule that deals with coaching links. And that provision was passed in 2015 by TSSAA to prevent coaches from using their extracurricular contacts with athletes to steer those athletes to the coaches' schools. The plaintiffs then proceeded to build this lawsuit around what we contend was a falsehood. And that was the falsehood that Penny Hardaway didn't really coach Team Penny, that he only sponsored the team. The evidence in this case showed without question that Penny Hardaway coached Team Penny. He continued to actively coach the team at practices, and that evidence is detailed in our brief on pages 28 through 30 of the brief. And
let me ask you, I know now, from reviewing your briefs that you argue that Mr. Hardaway perhaps coached the team under the definition of coach. But when the decision was made in 2017, as I understand it from looking at the record, the decision was based on sponsorship of an AAU team. Is that accurate?
That's correct.
Okay,
That's correct.
So sponsorship was the reason given for finding them to be ineligible. Is that right?
That's
okay.
Right, because TSSAA took Penny Hardaway at his word when he denied having coached the team and said he only sponsored the team in a conversation in April of 2017 with the TSSAA executive director. So yes, TSSAA took him at his word when he said that in their initial decision in this case. My reason for pointing out his coaching of Team Penny that came out not only in discovery, but came out in James Wiseman's sworn complaint against the NCAA last year, it is that we asked the Chancery Court, and we believe this court too should consider the clean hands doctrine and consider whether the plaintiffs are rightfully before any court for what is purely equitable relief in light of their own dishonesty behind this claim. But be that as it may, our primary contention here is that the chancellor erred in applying the Open Meetings Act to TSSAA. And that was the basis on which he vacated the rule in question, and he not only vacated TSSAA's decision, but he affirmatively granted eligibility to these two athletes. The Open Meetings Act applies to governing bodies, and it has a very specific definition of what's a governing body in TCA 844-102B. Now, I don't think there's any issue. TSSAA is not one of the 4 or 5 types of nonprofit corporations that are specifically described in the Act as being a governing body. Those don't encompass TSSAA. The question is TSSAA a public body under the first paragraph of that definition? In Doria versus Dark, the Tennessee Supreme Court said that a public body to be covered by the Act has to be one whose origin can be traced to legislation, whose authority can be traced to legislation, and who makes decisions on policy or administration that affects the conduct of the business of the people in the government sector. They've got, a body has to satisfy all 3 of those components under Doria versus Dark to be a public body. On page 21 of their brief, the plaintiffs have conceded that TSSAA's origin cannot be traced to legislative action. That concession alone should end their Open Meetings Act claim, where they say, while the TSSAA was not created by a legislative act, its authority can still be traced to legislative action. Authority is only one of the components. And we
Let me ask you, Mr. Colbert, didn't we decide in City Press that because of the services provided by TSSAA in terms of public education, that it was the functional equivalent of a government entity, and that it fits the definition of a public body? Hasn't that already been decided?
No, Your Honor, yes and no. Yes, you did decide that TSSAA was to be treated as the functional equivalent of a government agency, and you in doing that, the court relied, as the Chancery Court had relied on what was really not a complete record in the Brentwood Academy case, because that was a case that went up on an interlocutory appeal to the Supreme Court. But the functional equivalent doctrine is a doctrine that is unique to the Public Records Act. It was adopted. The court in the I think it was a Memphis Publishing Company case, surveyed cases from other states, primarily Connecticut, I believe, and developed the public record, the functional equivalent doctrine for application to the Public Records Act, because the Public Records Act doesn't really say who it applies to with any specificity. But that act is unique to the Public Records Act. It's never been applied to the Open Meetings Act in any case in Tennessee. All of the cases applying it have been Public Records Act cases, even in other states. And the Open Meetings Act, unlike the Public Records Act, has a very specific definition, a very specific statute of who is covered by it. So respectfully, while the court did apply the functional equivalent doctrine in a Public Records Act case in City Press, that has no application in an Open Meetings Act case, because the two statutes are different. And this statute specifically defines who's covered by that. That's why if you look at, for example, a couple of the Attorney General opinions that the plaintiffs have cited in their brief, one of them is 16-16, the Attorney General, when looking at whether the TSBA and TOS had to comply with the Open Meetings Act and the Public Records Act when they helped a local school system do a director search, they found themselves engaged in two quite different analyses, because it was a simple analysis under the Public Records Act, But under the Open Meetings Act, they had to look back at Dorier versus Dark and ascertain whether TSBA or TOS would meet the definition of a public body for purposes of the Open Meetings Act, which is a different question.
Well, let me ask you, don't we have an attorney general opinion that says that if a public agency delegates a portion of its duties and responsibility to a not-for-profit, such not-for-profit is a public body? Don't we have an attorney general opinion that says that? Although obviously we don't have to follow that.
I don't think the attorney general said it is. I think the attorney general said it may be, but you still have to look at the origins of the organization for purposes of. I think that opinion is the 2009 opinion, I believe, that they cited, and the attorney general didn't come to a complete conclusion in that opinion, but they said you still have to look at the origin of the organization to decide whether it's a public body under the act.
And then in that opinion, they were looking at whether or not that not-for-profit would be subject to the Open Meetings Act, not the Public Records Act.
That's right, but they said you still have to look at the things that Dorier versus Dark says you have to look at, which include the origin. Does the origin come from legislation? Does the authority come from legislation? And are they engaged in the business of the public? That they talked about the business of the public, which is only the third component of that three-part requirement. TSSAA's origin admittedly doesn't come from legislation, and its authority doesn't come from legislation. The State Board of Education, they don't depend on the State Board of Education for their authority. The State Board passed a rule 50 years after they started doing business that recognized what they do, but they are not a public body under the definition of a public body in Dorier versus Dark. Your Honor, my principal time is up. I don't want to use up all my rebuttal time. If the court doesn't have any questions, I'll have to rely somewhat on my brief.
Thank you very much. You do have your rebuttal time.
Thank you.
Yes, sir.
May it please the court, Andre Mathis of the Shelby County Bar, and I represent the Shelby County Board of Education and Dr. Hilliard in this matter. This court should affirm the trial court's decision finding that the TSSAA was subject to and violated the Open Meetings Act. This court should also reverse the trial court's dismissal of the SCBE petitioner's state law arbitrariness claim and the due process claims. I'll begin by addressing the Open Meetings Act. Now, the U.S. Supreme Court in Brentwood 1 has already determined that the TSSAA is a state actor subject to constitutional claims. And the City Press Court has already determined that the TSSAA is the functional equivalent of a government agency, making it subject to the Public Records Act. The final piece of the puzzle to make the TSSAA fully accountable to the public is for this court to uphold the trial court's decision finding that the TSSAA is subject to the Open Meetings Act. And it's important to point out here that courts construing the Open Meetings Act construe it broadly to promote openness and accountability. And as the TSSAA argued in City Press, there is a relationship between the Open Meetings Act and the Public Records Act. Obviously, the TSSAA is trying to distance itself from that argument at this time. Now, there are two reasons that the TSSAA is subject to the Open Meetings Act. First, the State Board of Education, which is indisputably a public agency, has delegated its responsibilities for regulating interscholastic athletics to the TSSAA. And second, under the Dorier framework, the TSSAA's authority to regulate interscholastic athletics can be traced to legislative activity, and the TSSAA's Legislative Council and Board of Control make decisions on policy and administration affecting people in the government sector, in particular public schools. Now, the delegation framework was developed by this court in Sadler after it determined that the Dorier framework did not address whether the not-for-profit corporation at issue in that case was subject to the Open Meetings Act. And as Judge Armstrong pointed out, under the Salad framework, an entity is subject to the Open Meetings Act if a public agency has delegated its official responsibilities and authority to that entity. And the policy behind the delegation framework seems obvious. We don't want public agencies essentially outsourcing their responsibilities to private entities and thereby evading their, the Open Meetings Act or the Public Records Act requirements. Now, for over 20 years, the TSSAA has made the same argument that it makes in this brief, which is that the State Board of Education did not delegate any responsibility to the TSSAA to regulate athletics, high school athletics. And they make this argument despite all the evidence to the contrary. There's literally almost 50 years of authority suggesting otherwise, starting with the 1972 regulation that the State Board of Education passed in 1972, where it specifically designated the TSSAA as the entity to regulate interscholastic athletics. And then there are various court opinions and AG opinions afterwards. In 1983, there's an AG opinion that stated that it's generally accepted that the State Board had delegated the responsibility of interscholastic athletics to the TSSAA. The 1990 Crocker decision from the Middle District of Tennessee stated the same thing, just as the Graham court in 1995 from the Eastern District of Tennessee also stated that the State Board had delegated its official responsibilities to the TSSAA. Now, that regulation was changed in 1996, but Brentwood 1, which was decided in 2001, and City Press, which was decided in 2014, both found that the change in the regulation did not change the fact that the State Board had delegated its responsibility to the TSSAA and indirectly controls the TSSAA. Now, Judge Armstrong referenced the Attorney General opinion, specifically the 2009 Attorney General opinion, where the Attorney General was asked to give an opinion on when a corporation like the TSSAA is required to comply with the Open Meetings Act. And the Attorney General actually gave 3 different scenarios in which a not-for-profit corporation could be required to the Open Meetings Act. The first scenario is when there's been this delegation of official responsibilities. The second scenario was if the corporation fell within the categories listed in TCA 844-102B, 1B through E. And the third was if the corporation satisfied the Dorier framework. And we submit that the first scenario applies here, the delegation framework. And of course, we believe that the Attorney General's opinion should be given considerable deference, even though this court is not bound to follow that. So we submit that based on Brentwood 1 and City Press, there can be no real doubt that there has been this delegation of authority. We submit that this court could also find that the TSSAA is subject to the Open Meetings Act under Dorier framework, even though, as we have conceded and acknowledged, the TSSAA was not created by a statute. But there can be no real dispute that the TSSAA's authority is traceable to legislative action. Specifically, the State Board of Education's interscholastic athletics regulation cites TCA 49-1302 as the authority for that particular regulation. And City Press and Brentwood 1 both found that the TSSAA's authority to regulate interscholastic sports comes from that regulation. The TSSAA also makes decisions that affect the governmental sector. There can be no real dispute that education is a government function. And in City Press, the court held that the State Board viewed the supervision and regulation of athletic activities as one of its government functions based on the interscholastic sports regulation. Therefore, the TSSAA's decisions impact the governmental sector in that they impact education and public schools. And we have to keep in mind that the TSSAA throughout this case and in its constitution and bylaws has stated that it provides an educational experience for these student athletes. The TSSAA argues that because it wasn't created by statute, that's the end of that particular analysis under the Dorier. But we submit that in the Attorney General opinion, this is the 2016 opinion, suggests otherwise. While that opinion states that normally an entity that wasn't created by a statute wouldn't be subject to the Open Meetings Act, there are factors that this court can consider. And those factors include looking at the organizational structure, looking at the existence of members and how those members are appointed, the authority of the nonprofit corporation and the basis of that authority. And the question, the issue, as the TSSAA pointed out, was whether a school board could delegate its responsibility for searching for a superintendent. Could delegate that responsibility to third parties. The factors, we went through those factors in our brief, so I won't spend the time going through that now.
Well, let me ask you, how does the legislature's enactment of 49-132 affect our analysis as to this case, Mr. Mathis?
Under the Dorier framework, I think that shows that particular enactment shows that the state board's authority or the TSSAA's authority is traceable to legislative action because the state board relied on that particular statute in enacting the interscholastic athletics regulation. So, Your Honor, we submit that if the court finds that the Open Meetings Act applies to the TSSAA, there's no dispute that the TSSAA has violated the act. The Board of Control has acknowledged that, it met privately to make the decisions that it made in this particular case. And obviously the TSSAA has argued throughout these proceedings that it hasn't been required to comply with the Open Meetings Act. We submit that the trial court failed to provide some of the remedies that are required under the Open Meetings Act, and that is the 1 year mandatory injunction. The permanent injunction and the 1 year period of maintaining jurisdiction to ensure that the TSSAA actually complies with the Open Meetings Act. Beyond the Open Meetings Act claim, we also brought a claim asserting that the TSSAA acted arbitrarily in its application of the athletic coaching link rule. Now, normally based on Cox and the Cox line of cases, courts normally lack jurisdiction to adjudicate decisions of voluntary associations unless that the association acts illegally, unconstitutionally, or arbitrarily. And just over a year ago in Robertson, this court opined that an association acts arbitrarily if it fails to follow its bylaws, or if the bylaws fail to explain the rule and the consequences of violating the rules. And here we submit that the TSSAA failed to follow its bylaws. The athletic coaching rule identifies four coaching links that could cause student athletes to be ineligible. And the TSSAA has admitted that its decision was not based on any of those four links. Instead, it was based on an unwritten sponsorship restriction that's nowhere mentioned in the rule, and that the body that created the rule considered and still failed to include it in the rule. Not only does the rule not mention anything about sponsorship, the bylaws also include examples of when the athletic coaching league rule applies. And none of those examples mention or suggest that sponsorship would be a restriction under the athletic coaching league rule. And not only that, we also have, the different situations in which the TSSAA has applied the athletic coaching league rule. And other than this case, the TSSAA has never used this unwritten sponsorship component. Now, the TSSAA has argued in this brief that that the links in the rule are only examples, number one, and number two, that it explained at meetings that the rule would apply to sponsorship. Well, the problem with this argument is that there is nothing in the rule to suggest that that the links identified there are non-exclusive. And in fact, when the TSSAA has used other language when it wanted a rule to be non-exclusive, such as in its bylaws, such as including but not limited to, or may include but is not limited to. Now, with regard to this notion that the TSSAA could, I guess, verbally amend its bylaws by talking about sponsorship at meetings, a couple of points here. First, our athletic director attended one of these meetings where it was supposedly told to everyone that sponsorship would be included in the athletic coaching league rule. And she testified that she didn't hear the TSSAA's officials mention that sponsorship would be included in that rule.
Let me ask you, Mr. Matthews, in your brief, you say that the Legislative Council considered sponsorship, the sponsorship rule, but rejected it. Is that disputed?
I think the TSSAA disputes that it was rejected. I think the TSSAA has argued that this was a non-exhaustive list, and they can just decide after the fact what all could be included in there. But I don't think there's any dispute that sponsorship was actually considered by the Legislative Council at that time, and that nothing about sponsorship made it into the rule.
All right.
So not only did the TSSAA fail to follow its own rules, the TSSAA's bylaws failed to explain that the rule applies. So even if TSSAA officials explained that sponsorship was in the rule, that would be insufficient under Robertson and Cox. And Your Honors, I see that I'm out of time. I'll rely on my briefs for my remaining arguments. Thank you.
Sir. Mm-hmm. Your rebuttal?
Yes, Your Honor. First of all, let me say, and I wanted to get to this earlier, even if we assume for the sake of discussion that the Open Meetings Act is to apply to TSSAA, it does not justify the relief that the Chancellor gave to the plaintiffs in this case, because what the Chancellor did was voided the coaching link rule, and he declared these two student athletes to be eligible, basically voiding the Board of Control's decision that they were ineligible. The proof shows, the undisputed proof shows, that the rule in question was adopted by the Legislative Council of TSSAA at an open meeting on September 1, 2015. It was discussed, it was considered, it was adopted at that meeting. That meeting would satisfy the standards in Nice, in the Nice case, even if the meetings of the committee that worked on an assortment of different rules to address public-private disparities in competitive equity, even if that committee didn't meet in public, because that committee only had the power to make recommendations anyway. The Legislative Council that adopted the rule met in public. So it wouldn't be appropriate to simply vacate the rule under the Open Meetings Act. As to the eligibility decision itself, the one in question that the Open Meetings Act would arguably apply to was a meeting on an appeal by the TSSAA Board of Control. But the initial eligibility decision was a decision by the executive director. And the Open Meetings Act wouldn't apply to the decision by the executive director, because that's not a meeting of a public body anyway. That's an individual administrator's decision. You combine that with the fact that under the TSSAA transfer rule, the default position for a student who changes schools is ineligibility until there is an affirmative approval of eligibility by the TSSAA. The default is that the transfer student's ineligible. So for the chancellor to step in on the basis of voiding the Board of Control's decision and to say he's going to ignore the executive director's decision that was appealed from, and he's going to ignore the default position under the rules, and he's going to make these two student athletes affirmatively eligible is really the height of disregard of the Cox doctrine that the court is not to interfere in the internal affairs of a voluntary organization. The chancellor effectively undertook it upon himself to make an eligibility decision that the rules give responsibility for to the executive director.
Mr.
Finally,
Colbert, what relief can we grant these two students now? As I understand it, both have graduated. Wiseman is in the NBA. I don't know where Boyce is. So what relief can we grant?
Grant to them?
Yes, in connection with this case.
I don't know that there's any relief to be granted to them now, but I don't think the case is moot if that's what the court is, if that's what Your Honor's question is getting at, because.
Well, yeah, this is not a declaratory judgment, is it? Action.
It wasn't a declaratory judgment action. It was an action for injunctive relief.
Right, and the injunctive relief was to do what?
Was to do what the chancellor did, make the rule void and declare the student athletes eligible. And he entered a temporary injunction, which got. But
there's no way for us now to grant them eligibility, is there?
No, I don't think there's any way for the court to grant them eligibility. I don't think it's appropriate it was appropriate for the chancellor to rule retroactively that they were eligible either.
All right.
I don't think voiding the Board of Control's decision gets you to the next step of retroactively concluding that they were eligible, and that implicates the reasons why this case is not moot, because they played what were two ineligible players under the TSSAA rules, and they won a state championship with their help.
Thank you very much. Gentlemen, your case has been submitted to the panel. You will receive our opinion within the due course of time. Thank you very much.
Thank you, Your Honor.
This honorable court is now in recess until 2 p.m.